There's just so much case law going back like more than 100 years that tells us the contrary to his argument. I cannot actually imagine a situation in where the Supreme Court really did say, yeah, every president from here on out, even when they're gone from office, you can't do anything about it.
Welcome to Law and Chaos. Today we'll be joined by Brandi Buchman, a reporter for Law and Crime who's covered many of the January 6 cases in D.C. She was in court for the trials of the Proud Boys and the Oath Keepers. Militia groups were convicted of seditious conspiracy for their role in the plot to overthrow the government. She'll talk about those cases and how they lay the groundwork for the prosecution of Donald Trump. We got a lot to cover, so let's get after it. Hey guys, it's Liz Dye. We have a really good interview today with Brandi Buchman, who's written just everywhere. She was in the room when the government prosecuted the domestic terrorist militias, and she's got some interesting predictions about the upcoming Trump prosecutions in D.C. and Florida. We are, as we record this, still waiting for the Supreme Court to tell us if they're going to do Trump a solid and allow him to screw around and make his doomed magical immunity claims for long enough to put his election interference case off until after November. In the meantime, let's just take a moment to appreciate the little things that give us joy in this life, like my pillow fluffer Mike Lindell getting spanked in court.
When you say lumpy pillows, now you're an asshole. You got that? You're an asshole, is what you are. He's an asshole. No, he's an ambulance-chasing asshole. That's what you are.
Obviously, that's Mike Lindell all up in his feelings. It's clip from a deposition in one of his defamation cases, because our Mikey spent much of 2021 flogging fantastical lies about voting machines being hacked by China or Iran or maybe General Zod. He even threw this crazy cyber fraud hootenanny hoedown in Sioux Falls, South Dakota in August of 2021 so that everyone could see his amazing proof that all the voting machines had indeed been hacked. In fact, he was so sure of his evidence that he sponsored a $5 million Prove Mike Wrong contest to put his money where his mouth was. And he was going to let experts verify his claims of election fraud. Wait for it. So Mike Lindell was convinced that the key to this evidence lay in packet capture data, aka PCAPs. And I'm on a level witches here. I do not understand what packet capture data is, even after watching Mike Lindell's docudrama Absolutely 9-0, wherein he explained that after seeing his immaculate PCAP data, the Supreme Court was going to unanimously overturn the election and make Trump president again. After watching this movie, I can say with complete certainty that, like me, Mike Lindell does not know what PCAPs are. In fact, after the FBI seized his phone at a Hardee's drive-thru in 2022, he claimed that the government was destroying his business because he runs it through his phone because he doesn't own a computer. But you know who does own a computer? Software developer Robert Seidman, who entered this contest and proved conclusively that none of the gobbledygook data proffered by Lindell contained PCAPs, and thus none of it could be election information establishing that the voting machines were hacked. But when Seidman asked for his $5 million prize, Lindell said no way. So, in accordance with the rules of the contest, Seidman took Lindell to arbitration, and the arbitration panel unanimously agreed in April that Seidman had won the money fair and square, so too bad, so sad for you, Pillow Man. But Mike Lindell did not get where he is in this life by backing down from a fight, no matter how ridiculous. So he shouted some more nonsense about getting the ruling overturned in court, and he sued Seidman, who promptly sued him right back. But, funny story, it's functionally impossible to get an arbitration ruling tossed without evidence of corruption. Like, you can't just march into court and say, the arbitrators got it wrong, Your Honor. Please don't make me pay up. Well, I mean, yes, technically, you can do just that, but it's not going to get you anywhere. And indeed, it did not get the Pillow Man anywhere, which is why on Wednesday, a judge in Minnesota ordered him to pay the $5 million plus 10 months of interest for all the time he spent making Seidman participate in this stupid pillow fight. So womp womp, and let us all take this moment of joy. All right, so just a bit of housekeeping before we get to the show. First, obviously, this is dropping on a Friday, not a Monday. And in fact, we've been putting out bonus content on Fridays for a while, and now we're going to make it official and see how it goes with 2 pods and 1 written post each week. There's just a lot of news, and we're not able to cover it all at once. Plus, you guys have been really supportive at both the Substack, which is lawandchaospod.com, and on Patreon at patreon.com/lawandchaospod. For the Patreons, we're going to make this second episode free this week, but going forward, you may want to adjust your pledge or your monthly cap so you don't get a surprise charge when we ramp up content. And speaking of ramping up, I am excited to announce that we will be having our first event on the evening of March 7th, a YouTube Q&A with me, moderated by my pal Stephen Robinson, aka the Playtyper Guy. We will be taking questions from paid subscribers, but the event is free to anyone on the Law and Chaos YouTube channel. So stay tuned for more details on that one. And with that, let's pay some bills and get on with the interview with Brandi Buchman. And with us today is Brandi Buchman, an independent reporter currently freelancing at lawandcrime.com. She covers the Trump trials in D.C. and nationally, and you should definitely check out her coverage at the site. She was also in court for many of the January 6 prosecutions, including the Proud Boys and the Oath Keepers, and she's working on a book about those trials. Brandi, thank you so much for being here.
Thanks for having me, Liz. I really appreciate it.
Okay, so let's talk about what's coming up for Trump in D.C. and Florida. I think we ought to maybe hit those federal cases. But maybe before we get to Trump, can we talk about some of the lower level offenders? What was it like to cover all those January 6 prosecutions?
Yeah, gosh, it has been, I think, almost a year now since some of these cases with the Oath Keepers and the Proud Boys were sort of first starting to come together and, get underway in the courthouses. But, I will say that there have been a lot of people that have been processed through the courts for January 6th. A lot of folks did a lot of bad things that day, but chief among them are the people who were charged with the most serious crimes that we've seen come out of all of these prosecutions, the seditious conspiracy charges, and I think for good reason. Right. So much of what we saw, I think really sort of flies under the radar even today in terms of, the impetus that people had to follow his lead and to stop the certification. It wasn't just a lot of heated rhetoric with these guys. While there was a lot of that, there was planning and a conspiracy that was underway. And so, just to sort of see where we are now in terms of all of the indictments that Trump is facing, and particularly the indictment in D.C., it really does kind of put a unique perspective looking back on those trials for me. I think that without those prosecutions, without going after them specifically for seditious conspiracy, it in its own way might have made it more difficult for the government to say, hey, Trump really did try to incite violence on January 6th. There really was a belief among people that he could invoke the Insurrection Act and that he needed to raise a militia to his aid,
Yeah, and I think that's especially true, as you said, with the seditious conspiracy charges, which were centered around these 2 actual militia groups, the Proud Boys and the Oath Keepers. And you covered both those trials.
Yes. Yeah. Yeah. I mean, what we saw, with the Proud Boys and the Oath Keepers, there were many similarities, but there were also a lot of key differences. And the key difference being between the Oath Keepers and the Proud Boys, they were both sort of motivated to stop the certification. Mm-hmm. One group, the Oath Keepers, genuinely believed that there was going to be a formal call by Trump at some point, to basically come up to his aid, help them stop the certification, keep him in the White House, and do whatever they would with, any of their opponents. The Proud Boys didn't really have a plan insofar as, the Insurrection Act. They wanted to wreak havoc and chaos, and they wanted to use a lot of the people that were already there to sort of help them with those ends. And, interestingly, as we've seen a lot of these January 6 cases sort of roll out in just the recent weeks, I'm starting to see how a lot of the defendants who were physically around Proud Boys, who, knocked over barricades and all the rest, they've been kind of getting ticked off by the Justice Department prosecution one after one. So they're kind of moving in these, outward circles, it feels like to me.
Yeah, it's interesting because the Oath Keepers really sort of saw themselves along, I think with the Three Percenters as well, as kind of a vanguard of an orderly America that didn't exist. And whereas the Proud Boys have always been kind of drunken brawlers, and it was kind of never the twain shall meet, except that they did meet, right? Like Stuart Rhodes met with Enrique Tarrio.
Yeah, they did. I mean, they had a meeting in an underground garage on January 5th, January 4th or 5th. I'm blanking on which ones. You have to correct me on that. But there was a meeting the eve of the insurrection. Enrique Tarrio, the leader of the Proud Boys, was headed to prison had been ordered out of D.C., excuse me.
Right. He was with me in Baltimore, hanging out.
Right. Yeah, yes. He was ordered out of D.C., he was in Baltimore.
Yeah, he was in Baltimore because he had, I think in December, been in D.C. for another riot protest and had stolen a Black Matters flag and burned it off of a historic Black church, is my recollection. And as he was coming into the city, the D.C. cops knew that he was coming. I don't remember if it was the D.C. cops or it was the feds, knew that he was coming, intercepted him, and he had some sort of... it wasn't a gun, but it might have been like...
No, it was like a mag. It was like a magazine for it. It was a decorative magazine for it, with the Proud Boys logo on it. Yeah.
Right. And they basically arrested him and said, "Don't be around here on January 6th.
Right.
Get out of town."
And he gave himself, the perfect alibi to say, oh, look, I knew that this was all going to happen on the 6th. He knew that Trump was going to hold a rally on the 6th. Mm-hmm. He knew that lots of people were planning for it. We saw at trial, an extensive number of chats that were specific just to the exclusive group of Proud Boys that Tarrio led, which he called his Ministry of Self-Defense. Yeah. We saw chats called Boots on the Ground. We saw them all sort of planning. So Tarrio, in my estimation, based on what we know, he knew full well that if he came to D.C., he could give himself an alibi by getting arrested and ordered out. And, he took his sweet time getting out of D.C.
Yes.
And then he watched everything happen the very next day. So, yeah, I think it sort of goes toward, another key difference. Tarrio was watching from way far away. Stuart Rhodes, the leader of the Oath Keeper, he was on the ground outside. He was calling the shots. These guys are very different guys, and in a lot of ways, very much the same.
Can I just pull on a thread that you said before?
Yeah.
You think that Tarrio got himself arrested on purpose so that he would have an alibi? I've not heard that. That's such an interesting thing.
I really do. I think that for the purposes of our conversation, like everything that I've seen contextually around this and knowing what we know about the kind of manipulator that Tarrio is, both with his own people, with the public, pretty much everybody. There was, he was aware that there was a warrant out for him when he came into DC. That I know for a fact, that we saw evidence for. So, for him to waltz in a day before this real big day, I never bought that to be a credible, position or argument from him.
Oh, that's so interesting. And can I ask another question? We'll get back to Stuart Rhodes, but let me ask another question.
Yeah.
How do we have those chats? Because I've seen a lot of those chats, and I have, suspected how we got those chats. But how do we have those? Because I think they were like encrypted, or they were on Telegram. They weren't on Telegram.
On their phones, most of them use Signal, and so when the feds got a hold of some of the defendants' phones, when they got a hold of other people's phones, and had a chance to kind of piece together all of these conversations, we saw in both groups, in both instances, Oath Keepers and Proud Boys alike, but particularly the Proud Boys, just massive amounts of communications. We also had a chance to see one or two videos of Zoom meetings, essentially, that they had with their private groups where they're like talking in code. And yeah, exactly. So, it's like they didn't do a very good job, unsurprisingly, of sort of covering their trail. And I think that they relied very heavily on like plausible deniability, which was a key defense for pretty much everybody in both of those trials,
Right. I mean, that goes to your point that Tarrio did, in fact, try and get himself arrested so that he would be not there and not not be involved.
Yeah.
But I will say, you're a reporter, I'm a reporter. If you still have messages on Signal when somebody gets your phone, you don't know how Signal works. You're just like
Right.
bad at it. I don't think that these guys had any claim to being like masterminds.
No, I don't think so either. And also I wanted to mention too, like another reason why we sort of know this about Tario, when we were at trial with him, we saw the communications that he had with Shane Lamont, who was one of, I believe Shane Lamont is Metro PD, if I'm not mistaken.
Mm-hmm.
He was an officer, who was charged with basically inappropriate behavior because he was having this conversation with Tario, sort of feeding him information. And that was another thing Tario said, he was just trying to help the police prepare for the Proud Boys coming on for the Stop the Steal rally, the MAGA March, all the rest.
Right.
So a lot of these little interesting coinky dinks just kept happening over and over again, throughout all the evidence that we saw.
Okay, so let's go to the day. It's January 6th. Mm-hmm. Tario is in a motel in, like Anne Arundel County or Baltimore, wherever he is. He's in some motel in Baltimore.
Baltimore, yeah.
Right? The rest of the Proud Boys, his guys, are on the ground, and the Oath Keepers are there. Now, what happens on that day?
So there's there's a confluence of factors that are happening. First, we have to understand that as far as we know, there's not a whole lot of communication that's going on between these two groups. Now, there was like one-off messages here and there that were flying back and forth around that time between people who knew people, who were associated with one another. But by and large, these groups kind of stayed separate. But as this is happening, at the key moments, we have Oath Keepers who are breaching the Capitol, coming up the stairs in a stack formation, one by one. They're getting direction from Rhodes, indirectly in some ways, more directly in others. Hey, I'm going to be on this side. There's a lot of activity going on over here. This team is on this side. This team is going up the stairs at this time. And then once they get inside, they're reporting back to a group chat. The Oath Keepers are reporting back to a group chat, which is being read by Rhodes, as far as we know, and as what we could see. And like the Proud Boys are they're starting out their day predominantly at the Washington Monument. And they move from the monument, they walk all the way down to the Peace Monument, which is a statue right in front of the Capitol. And then the argument by the prosecution and what we sort of saw play out, well, we definitely saw that play out in the evidence, and the jury believed this too, that, the Proud Boys were sort of loosely guided by a rough idea of what they were told to do. They were all told, hey, follow Ethan Nordine, who was one of Tario's leaders and co-defendants at trial. Follow Joe Biggs, another guy who was a co-defendant to Tario and another leader in the Proud Boys. And, listen to what they're going to do. And then Zachary Rell, who was another co-defendant who was there, he was also a leader in the Philly chapter for the Proud Boys, but he was sort of like a tertiary leader to Biggs and to Nordine. And he was just sort of like repeating back to them, we're going to move here, we're going to go here, when they could figure out what they were doing. But the key thing is, and this was an argument that was, or something that was offered to jurors when they closed the trial, a lot of the Proud Boys might not have been as organized as Oath Keepers were, with all of their reports back and the stack formations and all the rest. But what Proud Boys had enough organization to do, at the very least, was once they were standing there, right before people started knocking over barriers, right before they started charging the Capitol, they took a look around. And they had the awareness of, okay, this is what's happening. We're going, let's go. And then once people started rushing, and reminder, Biggs is riling people up, with a megaphone before this. Nordine is riling people up with a megaphone. The election is stolen. Trump has had the election, all this. And then once they sort of get everybody into a fever pitch and there's a little bit of movement, they go. And then from that moment forward, we see this again. And we had testimony at the Proud Boys trial too about people who realized there was a guy, and I'm blanking on his name right now, you'll have to forgive me, but there was a gentleman who testified at trial who said that once he looked up, and once I think he was on one of the plazas up on the Capitol. Once he looked up and he realized that they were really doing this, that they were really going inside, he had the thought in his head, oh, S word, this is happening. And so it's like the defense tried to argue, well, see, this is proof that, nobody had planned until the second that it happened. But the prosecution said, we never needed to prove that. We never even needed to prove that there was an explicit plan. All we have to do to get the charge on sedition is to prove that there was an implied understanding. They said it like this. I think Nadia Moore, the assistant U.S. attorney, said, Imagine you're at a traffic light and you're at a red light and there's a car that pulls up to you at the light. And you look over at them and they look over at you and they rev their engine and you rev your engine. You have an implied understanding that you are going to race as soon as that light turns green.
Oh,
you don't need to have you don't need to have an agreement beforehand. And I think that, that was the thing. There was a lot of pushback from Proud Boys on that line of defense, but they got demolished underneath the weight of it for the most of it.
So, okay, we all know what happened, right? The Proud Boys got convicted and so did the Oath Keepers. What do you think that means for the Trump prosecutions?
Yeah. I mean, I think that when I was covering these trials, it was hugely concerning to me that the prosecution was able to secure convictions on these charges, and not just for one or two, but for most of them. Mm-hmm. And this was because, in my opinion, when it comes down to indicting Trump for a criminal conspiracy to subvert the election, to defraud people out of their right to vote, to basically completely abandon his responsibility to, run the transfer of power peacefully. I mean, look, without these people that are they can't just be chalked up to a bunch of rioters who got upset, a bunch of protesters, grannies and whomever that people want to say, really showed up at the Capitol. No. The Oath Keepers were by the dozens. They were months into this. Every time Trump said anything that, remotely about election fraud, Stuart Rhodes carried it out into his masses. The Proud Boys knew going into this that, whatever Trump said, they would do. I mean, look, Oath Keepers came armed. Many Proud Boys came armed.
Right. They had a whole cache of weapons across the river.
Right across in the river, right. And I mean, in order to show how serious that threat was and how serious people took it, and to really kind of put a pin on that, I think having the convictions and having all of the evidence that we saw in both of those cases helps. Trump did conspire. If you look at all of the evidence there, if you take the prosecution at its word, he conspired to overturn the results of the election. Mm-hmm. That conspiracy didn't just happen in a vacuum. We go all the way back to September 2020, when he first told Proud Boys, stand back and stand by. Long time building. I think that it would be really hard to bring a lot of the arguments about his incitement to violence and his real role in it without those convictions,
Can we just take a little dog's leg here? Because you and I have both covered some of the lawyers involved. So, I also am pleased that they got these convictions, but I do sometimes wonder if they had different counsel, whether it would have come out differently. I mean, I think if they'd had different counsel, most of them would have pled in some fashion instead of rolling the dice. But they did have some colorful lawyers.
They sure did, yeah. I think that the Proud Boys defense lawyers, I mean, first of all credit due to defense lawyers everywhere. It's 100%. Not an easy job.
No, and these are, extremely unliked, these are unpopular defendants.
Exactly. But I think that a lot of the issue for the defense attorneys in the Proud Boys case, and there was two in particular who sort of stood out to me, which was Carmen Hernandez, who is Zachary Rel's attorney, and then Norm Pattis, who is the attorney for Joe Biggs.
Yeah. Norm Pattis is a famous figure. I mean, you and I have written about him a lot. He represented Alex Jones. He was he was the one holding the bag on that $1 billion verdict in Connecticut. He was he's also, well, we'll talk about it. He was invited to not be a member of the bar anymore by the judge in Connecticut because he was part of the chain of events that wound up with the contents of Alex Jones's phone going to the plaintiff's counsel in that case, and the fact that on that phone and passed around to all and sundry were the plaintiff's medical records, which was totally not supposed to be there. So Pattis is quite a character in his own right.
He is. And as repulsive as some of his worldviews might be to the person who just stumbles upon him, on average, the judge in the Proud Boys case really had a soft spot for Norm. I mean, it was so...
Judge Ahmed Mehta?
No, this was Judge Tim Kelly in the Proud Boys case. Yeah.
I'm thinking of the other lawyer that we're going to talk about in a second. Yeah.
Judge Kelly had a lot of patience for Norm, I think, because he just found him to be kind of amusing as a person. But to Kelly's credit, he would let Norm run, I think, a little bit longer than everybody else in that room, but he would eventually, he would put the kibosh on him, and he was rather firm with him. But I think the most striking thing that came out of the defense strategy, I guess you could say, was what happened with Carmen Hernandez. So, Carmen made this critical error, one could argue, as we were getting toward the tail end of the trial when it came down to Zachary Rell. Zachary Rell is this young baby face guy. He got up on the stand a couple days prior to when she had him up there for her cross. And until he opened his mouth, I think he would have done fine. And I think that there was a while there where
always the way.
Always the way. I think there was a while there where I thought, you know what, if they can manage it, he might walk on a lot of these charges, Zachary Rell in particular. But as it turned out, Carmen Hernandez, I think we had a 4-day weekend that was coming up one Friday, or one Thursday rather. We had a 4-day weekend coming up. She knew that he was going to have to face some really tough questions about what he was doing on January 6th, because there was some details out there about maybe he had assaulted police with some pepper spray. Maybe he had details. Right. The details hadn't really been, put together completely as it would seem for the prosecution at that point. And she was really trying to control the narrative around him. So when she got to this point, she was asking him these series of basic questions on her examination. And it was like just the most minute question. It was taking forever. So we get to the end of the day, she eats up a whole day. So it gives the prosecution 4 days now to go through everything that he said and pick apart his testimony. And then sure enough, when they come back, after the weekend, prosecution comes back and they have, lo and behold, a picture of Zachary Rell holding a device with what looks like pepper spray shooting out at it at police officers. We hadn't seen that in court up until that point.
Oh my goodness.
So, the defense strategies were very different depending on the attorney that you had. There was a lot of tension between a lot of those attorneys. You could tell a lot of them just wanted to get out of there. It was a long time that we were there. It was like more than 40 days, I know.
Oh my goodness.
So I think that for them, it was like trying to sort of wrangle in all these kittens. Roger Roots, who was one of the attorneys for Dominic Pizzola, he didn't do a whole lot of talking at trial. And I would presume to say because every time he opened his mouth, he was met with some kind of harsh rebuke from Tim Kelly for just being completely off subject, going into like crazy conspiracy lands about the deep state and Fedsurrection. I mean, that's what we were dealing with. It's like people advocating conspiracy theories while we have evidence and discovery that we're supposed to deal with. You know what I mean?
Yeah. And I mean, look, some of those lawyers, as you know, were funded by Sidney Powell's charity. And I'm putting some air quotes. I think that they've perhaps dealt with their IRS issues by this point, and so maybe they really are a charity. But that they funded a lot of the lawyers, and so the lawyers that they funded were people who believed this kind of horse shit, which is my podcast. You're allowed to say it, horse shit anytime you want. Funded some of this horse shit about the election. So one of those lawyers, I think, was Jonathan Mosley. I'm not 100% sure that he was funded by Defending the Republic. I'm not sure. I think he kind of refused to say at some point. But he's no longer with us as a member of the bar because he got disbarred in the middle of the trial for like 15 different things. Although he did continue to try and represent. Was it Meggs? Was it Kelly Meggs that he represented?
It was either Kelly Meggs. Honestly, we'll have to double check this because the thing that sticks out in my mind with Jonathan Mosley was all throughout the Oath Keepers trial, his constant harassment of me on Twitter, like the definition of a stack formation. I mean, my God, every time I would look down, it would be John Mosley telling me what is or is not a stack formation. So I feel like I've got a mental block out with some of his background.
Yeah, I mean, he was one of the ones who said that the Oath Keepers were there because they were going to be guards or something. That they were going to be some sort of Praetorian guard for the president. They were just, like crossing guards. And he said that they were going to sue the government and they were going to get all of Merrick Garland's money, and that didn't happen. Too bad, so sad. But okay, let's talk about Trump for a minute, because presumably he's going to manage to keep lawyers who are members of the bar.
Right.
I mean, I write for a living about Trump's lawyers, so I wouldn't swear to it. But let's talk about that, because he obviously has this immunity petition at the Supreme Court.
Yeah. I mean, to me, this immunity question, it's everything right now.
Right.
The Supreme Court is essentially going to decide whether or not it wants to answer this question of, does Trump have immunity essentially from criminal prosecution? Therefore, can he dismiss his trial in DC for January 6th? I mean, look, we know on the appeals level, they unanimously rejected it when they had the 3 judges decide. I think he might still have the ability to go on bank and see whether or not the full court will decide.
That's a bit of a sticky wicket, because the 3-judge panel said, we're going to stay this order while you appeal to the Supreme Court.
Right,
but if you seek en banc review, the stay goes away. We're going to issue the mandate, and Judge Chet can restart the trial. So Trump, because he wants to chew clock, has asked the Supreme Court to give him time to seek en banc review, which he will never get at the D.C. Circuit. He's not going to get that. And, even if he got it, he would still lose. But he would like to do that so that he can kind of chew more time up on the clock and run it out. But I don't think he's going to get that. I mean, what do you think of his claims?
I mean, look, when I spoke to Norm Eisen, who's a fellows over at the Brookings Institute, and we talked about this a week ago, I really think that he sort of summarized my own feelings on this as well, which is, he called it Trump's bank shot. It's his last great hope. It's the only thing he's got.
Right.
If he doesn't prove that he's immune from prosecution criminally, then he can't, I mean, what is he going to do? He can't dismiss these cases. He can't get rid of them anymore at this point. Something absolutely absurd would have to happen, like some kind of wild thing. I think some kind of wild mispractice would have to occur for him to be able to dismiss them. He is a citizen now. The appeals court ruled that you are a citizen, Trump. Now, whether or not he can say, well, I can't be criminally indicted because I was acting within my official duties, that's another conversation. And the argument that Smith has made was like, hey, listen, promoting conspiracies, promoting ideas of fraud, essentially inciting people.
Lies.
Yeah, right. This is not part of your official duties. And so I think that there's just so much case law going back like more than 100 years that tells us the contrary to his argument. I cannot actually imagine a situation in where the Supreme Court really did say, yeah, every president from here on out, even when they're gone from office, you can't do anything about it. And plus, like, the sequence of events that Trump says needs to occur in order for him to be even held criminally liable is essentially, well, I have to be impeached, and not just impeached, I have to also be convicted. And then if I'm convicted in the House and the Senate through the impeachment process, the political impeachment process, then you can bring charges against me. And I mean, look, I know that is there's a lot of debate right now about, where the impeachment clause goes in terms of, Trump's immunity and all this. A lot of people smarter than me are arguing it. But I think if I'm just looking at this realistically, if I'm looking at this, there's plenty of other incidences in which judges, in the past, very few, but I think it's like less than a dozen, but there are instances where judges, they are able to be held to prosecution for their crimes. Just because they can be impeached as well doesn't mean that they cannot be held criminally liable. So I just feel like he's sort of operating in this make-believe fantasy world because he needs to. If he loses this, then he can't avoid it. And if he wins it, well, then, he doesn't have to go to trial. He doesn't have to deal with any of this. I just don't think that that's logical or reasonable.
Yeah, I think I just want to break down a couple of things that you said. Just with respect to the impeachment, Trump's argument is that the impeachment judgment clause says that if someone is impeached in the House and then convicted in the Senate, he can then be criminally tried when he leaves office, right? That impeachment only then. But so then Trump says, well, then the reverse is, or the logical conclusion is, that if you're impeached in the House and not convicted in the Senate, then you can never be tried. And that's ridiculous. No real legal commentator thinks that. And as you said, there are judges who have been impeached and not convicted and then later tried for their crimes.
That's right.
So that's a dumb argument. And it's, I think, only marginally less dumb than the immunity argument which Trump is making, which is he's saying, I cannot be prosecuted for any of my official acts. Well, his lawyer just basically got spanked at the appeals court because Judge Florence Pan said, well, it would be an official act for the president to send SEAL Team 6 to assassinate his political rival.
Right. Mm-hmm.
And, you know, that would clearly be impeachable. And in your theory, if he did that 10 days before leaving office or 10 days before the election or whatever day he did it and was impeached by the House and not convicted by the Senate, then he could never after be prosecuted. And that cannot possibly be the law.
Can't be. I mean, look, Gerald Ford gave the preemptive pardon to Nixon to avoid the criminal prosecution because he understood.
And Nixon took it.
Yeah, that's right. I don't want to go through this. I don't want to put the country through this. We don't want to go through all that. Let's put this to bed. Let's be done with it because we know that he can be prosecuted. I mean, and that's just one small little example. But yeah, I mean, I think that Trump sort of treats the courts and sees the law the way that he envisions his fantasy world to be. And it doesn't matter how much evidence there is. It doesn't matter how much case law there is. It doesn't matter how many people are telling him in his ear and being paid a lot of money to tell him, good legal advice. He is going to make whatever argument he wants to make to fit this dictatorial universe that he lives in.
Right. I don't think that even he thinks that he's going to win this immunity argument. It's ridiculous. It's contrary to all of the Nixon precedents. And look, the SEAL Team 6 argument is a good example of the logical conclusion of Trump's absolutist argument is untenable in a democracy. And so I think what he is counting on, though, is the Supreme Court giving him enough time, saying, well, this is important enough that we're going to have to brief the whole issue at length, at which point the trial will get knocked off the calendar. And then he can, get reelected and lock Jack Smith up, which, I just interviewed Jose Pagliari, and he made a really good point, one that I hadn't thought about, that when Trump is in court, Trump is not thinking about this trial or whatever is happening. He's thinking, when I get back in power, I'm going to throw this judge in jail.
Absolutely.
And I'm going to throw these prosecutors in jail.
Absolutely. Yeah, I would agree with that.
So, okay, let's talk about the Southern District of Florida, because presumably he does not have plans to throw Judge Eileen Cannon in jail.
No, she is working out very well to his favor. And today is Wednesday, I believe. So we had a sort of strange dynamic unfold in the last 24 hours. We had Trump make an offer to make things more streamlined for the first time maybe ever in his life by preparing what would have been a consolidated brief stating all of the reasons, essentially why he can't be tried in Florida, why he shouldn't be tried, vindictive prosecution, and all the rest. The immunity argument.
I'll read it to you because I think it's very funny. This is all of the reasons. He says he's about to file 10 motions to dismiss tomorrow, which is the pre-trial deadline. He says, on February 22nd, 2024, President Trump intends to file at least 10 pretrial motions concerning, for example, the appointment of Jack Smith, presidential immunity, the Presidential Records Act, selective and vindictive prosecution, the unconstitutional vagueness of 18 U.S.C. Section 793E, due process violations, prosecutorial misconduct, impermissible pre-indictment delay, the illegal raid at Mar-a-Lago, and improper violations of President Trump's attorney-client privilege. Okay. Similar to the motions to compel, for the sake of efficiency and in order to avoid requiring separate filings for each motion, President Trump respectfully requests permission to file a single consolidated brief in support of his pre-trial motions, et cetera, et cetera.
I mean, it feels like plausible deniability to me yet again. Like, I asked for everything to be in one shot, and she said, no, we have to break it apart.
That's funny.
Take your time.
It's so I'm a lawyer, and I look at it and I think, wait, 36 hours before, because he did ask on February 6th, he said, hey, maybe we could push this deadline off, which was to me a tacit admission that this trial is not going to happen in May. No one thinks this trial is going to happen in May.
Mm-hmm.
But that he was saying, well, since this trial is not going to happen in May, wink, wink, or might not happen in May, maybe we could push off some of these discovery deadlines. And Judge Cannon was like, nope. We're still pretending that it's happening in May so that I can squat on the calendar. And, if Fonnie Willis manages to stay on this case in Fulton County, she can't schedule that trial in June.
Right.
So tell me what your take was.
That was sort of my exact position as well on this. It was a delay tactic by him. I think it's just a chance to sort of break things down, make it go even slower. We also have to remember that we just had the trial date set up in New York for March 25th. Mm-hmm. So if we're going to be dealing with these motions, I would not be the least bit surprised. We're going to deal with one issue a week for 4 weeks. We're going to get to the end of March. He's going to say, oh, Judge, I'm so overwhelmed. I'm fighting a trial in New York. Can I get another deadline to file my next motion? Because you told me I should file this separately and I just want to abide by the court. All this kind of stuff. So I think that it's like, it's all manipulation. It's all an attempt to just sort of push things out as far as he possibly can. Because here's the thing, doesn't Todd Blanche also represent him in Florida and DC? Todd Blanche
also represents him in New York, right? Todd Blanche is his lawyer.
There you
right?
go.
Yeah.
So he knows what he could literally probably copy and paste a lot of these arguments. So I feel, at least for the immunity argument,
Right.
So I feel like, it just feels like it's being drawn out on purpose, and why Cannon did it, your guess is as good as mine.
So let's be clear. What happened is that Judge Cannon immediately said, no, you need to file 10 of your bullshit motions. You need to file 10 separate bullshit motions, because the game here isn't like, let's streamline this. The game is to make this go slower and slower and slower. And basically, it's a game of tractor chicken with the special counsel, because if the special counsel complains or tries to appeal, and we can talk about what the most likely method, which we think this is going to get delayed, but that if the special counsel says, I'm going to appeal one of your gonzo rulings, then she'll say, oh, I guess this trial is going to be postponed, and that was your doing, not mine. When
exactly,
clearly she's front-end loaded this, particularly with respect to the classified documents, because the arguments over those are so complicated. And the process under the Classified Information Procedures Act allows for an immediate interlocutory appeal of any classified documents rulings. So, there's a lot of stuff that's going on, mostly ex parte and sealed, but that it looks to me like she's trying to make the special counsel take an interlocutory appeal, which will stay the proceedings below and force the case off the calendar.
Right. Yeah, I don't think that you're wrong about that. And we still have to hear from her on this motion to reconsideration that he put forward, which was basically just, slamming her for what he called, quote, clear error in some of her decisions, particularly about revealing potential witnesses, specifically FBI informants that could be testifying at this case.
Yeah, let me break down what happened, which was that when Trump asked for permission to file one omnibus bullshit motion with all of his, vindictive prosecution nonsense in it, at the same time, he asked to file it in a redacted version on the public docket. And what's happening right now is that Trump filed a motion to compel. He's actually filed a bunch of motions that are mostly nonsense. And he would like to put discovery materials to buttress his claims on the public docket. And Judge Cannon said, yeah, go for it, because she said there's a presumption of publicity. Then the special counsel came back and filed a motion to reconsider, which sounds like I strenuously object. But what he said basically is, no, you're applying the wrong standard. You're applying the standard for trial materials, which are presumptively public, to discovery materials, which are not presumptively public, and for which there is an existing protective order, because some of that stuff involves witnesses, it's grand jury materials, it's stuff which absolutely does not belong on the public docket. So when Trump last night said, hey, we'd like to file our giant nonsense motion, and we'd like to file it in a redacted public form, Judge Cannon said, no, here's what we're going to do instead. We're going to argue behind the scenes, because, more arguing means more time chewed up. We're going to argue behind the scenes. You and the special counsel can argue about anything that's discovery materials, which the special counsel would like redacted, and you guys can brief it. And then next week, I'll think about your briefing, and eventually this stuff will wind up on the public docket. So there may be material, maybe we'll get to see one or two of these 10 magic briefs tomorrow.
Yeah.
But to the extent that there's anything that which is discovery materials, which should be redacted, we're not going to see it tomorrow.
Yeah. I mean, I think the element that interests me here as well is whether or not, depending on her response, this will generate an appeal from Smith against Cannon, and whether or not this will actually be like a third strike against her, given her history in this case of, sort of fudging around with the documents and slow walking everything. I'm really curious how that will go, and if Smith will actually, kick the can down the road on that, or if he'll really pursue that with her. I'm very curious to see how that will go down.
Yeah, I don't know. I have thought for a long time that the way this was going to get officially derailed, and to my mind, and I think most observers' minds, it is in fact already derailed. Like there's no way this is going in May. But that I thought that it would be through SIPA. I'm extremely interested to see how he thinks presidential immunity plays into his, like, I am a rando who kept documents and defied a subpoena and told my henchmen to delete the video camera footage, which should show them moving around this classified evidence. But I'm super interested to see how presidential immunity plays out in that one. But I don't know. But so last question, because you're here and I'm super excited to read it. Can you give us a little bit of the skinny on the book that you're writing?
Yes. So, the thing about both of the seditious conspiracy trials that went on was that while I think a lot of people knew that they were happening, there was just a really underwhelming amount of press coverage, meaning that there was myself and literally one or two other people who attended hearings religiously. And really, it was only one other person who attended every single hearing, maybe save for one, who was Roger Parloff over at Lawfare. And the thing that I sort of walked away from with that experience was that truly it was like the worst, most bizarre summer camp I had ever been to in my life, because it just went on for months and months. And it was such a strange cast of characters. The stakes were so incredibly high. I had a parent die midway. I got laid off midway. I mean, it was a nightmare on a lot of levels. It really felt like you were in a Groundhog Day situation, But, the book, I think, I'm trying to achieve two things here. I'm trying to bring people into the courtroom with me, like I attempted to do with my daily live coverage when I was there for both of them. I want them to really feel like they're not missing any element of what happened. I want to bring, the cold transcripts off of the page for them. And I also, want to give them a look into this process as it happens for a reporter on this beat. I was in DC briefly in the morning on January 6th. I got out of there before it got really crazy. And I had pretty much stayed on that beat nonstop ever since. It's been, 3 years now. And to see that come to a head, and to feel like this was exactly what needed to happen, no matter how long it took, and to finally see it play out was really something to behold. And I think that a lot of the lessons that I learned in that trial, just about how real domestic extremism is in this country, how everything really does just sort of hinge on the edge of a knife all the time. As far as democracy is concerned, it is an active process. That's something I want to impart to people. And the fact that the system still held, for all of its warts and flaws. We got convictions, and they weren't, across the board convictions. We had jurors who had the ability in DC to make discerning decisions and acquit some people while convicting others.
Wow. All right. Well, I am so grateful that you came, and I cannot wait to read your book. I hope you'll come back and talk to me about it then.
Oh, thanks, Liz. I'd love to. Thank you so much for having me. I really appreciate it.
All right. Thanks.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Up to Media, LLC, all rights reserved.